right, thanks very much. Appreciate it. Thank you all for having me here today. I'll make this as relatively painless as possible. Just so you guys are aware, the form changes come out in July 1st every year, and then you have a 60-day grace period to make the transition over. So hopefully most of you are using the forms by now, so that you've at least had some familiarity. But if you've been using these forms without knowing exactly what changes were made, we're going to go over those. Now, this first part of the presentation is the most important. If you pay attention during this part, you could actually just tune out the rest of the time and do your Wordle or whatever else you're going to do during this time period. So I'm going to share my screen. This is ncrealtors.org. Okay, this is the NC Realtors website, and here we house all our Q&As, which you can access after you log in. This Q&A button will show up, and you can see our Q&A categories right here. Now, we are going to get a new website pretty soon. I'm not sure when exactly that'll roll out, hopefully next year, but so this will change, but I don't think that the general scheme of the website will change. And what I mean by that is the Q&As will probably be hosted in one spot that won't be too difficult to find. So you go to our Q&As, and under forms, there's summary of forms changes, and there's some other folders down here, but we're going to be in summary of forms changes today. And what you can do is click on these summary of forms changes. Today, we're going to go over the July 22 residential forms changes. And when you click on that, this comes up. And this is a PDF that has not just notes. See here, it starts with the offer to purchase a contract, and it has notes about every single change that was made. But it doesn't just have notes. I'm not going to go through these notes today because that'd be kind of boring. What I am going to do is notice every form has a hyperlink. Okay, so any form that got a change has a hyperlink. If you click on those hyperlinks, it will take you to this. So this is 2T with all the changes in it highlighted. So you can see here, there's it went from a note to this right here. And we're going to go through these sorts of changes today. All right. So that's it. You can do your Wordle or whatever, but I will go through the rest of it for those of you that are interested in figuring it out. But this resource, don't feel like you have to take detailed notes on what I'm saying today. Honestly, pretty much everything you need is in this right here. And then don't forget, my law firm is Martin and Gifford in Winston-Salem. We're general counsel to the North Carolina Association of Realtors. And one of the things we do for the realtors is operate the legal hotline. So if you don't use the legal hotline, then I can give you that information. I think I'll might be easier to just put it in the chat a little bit later on. There's an email address and a phone number that you can call for the hotline. We give advice on forms all the time. It is a free service as a realtor member. And you can call and talk to us, figure out how to fill out a form. All right, so 2T had quite a few changes this year, so let's go through them. The first one is right here, and this came up as a result of closing attorneys that serve on the Joint Forms Task Force, which if you don't know, all these changes do not just come about because I think they're a good idea. As a matter of fact, I do only what the Forms Committee tells me to do. The Forms Committee is a group of realtors, and they discuss form changes. There's about 25, 30 of them on that committee. So it's a lot of input. It's a lot of experience. It's statewide. We have a lot of representation from all across the state. If it's a committee you're interested in serving on, then you can apply. And I think the application is in the spring. I cannot remember. But you can call the main office at Greensboro and they'll tell you if this is something you're interested in. A subsection of the Forms Committee is the Joint Forms Task Force. The Joint Forms Task Force is actually a joint committee between members of the Forms Committee and members of the North Carolina State Bar Real Property Section. And so they have their own meetings and go through all the changes. So when 2T, these changes that you're going to see in 2T today, They've in fact gone through 2 different committees before they even went to the executive board and were approved last spring. So in any event, so when I say this change came up because of closing attorneys, it was through the Joint Forms Task Force. Some closing attorneys brought up the fact that it's too often where a manufactured home will come up late in the transaction. And then it really throws off the timing of the closing and everything else, creates a huge headache for the closing attorney, and can be a real downer in the transaction. So what they wanted was something here besides just a note, something to indicate to the closing attorney whether a manufactured home is or is not going to be part of the property. Now, this doesn't, as it says, make sure you attach 2A11-T with this, okay? From the additional, that's the additional provisions addendum. Make sure you attach that anyway, but this will give the closing attorney a heads up. Small change right here, taken out by the effective date. So now it's just 5 days within the effective date as far as the checkbox. Mind you, if a party really wants it by the effective date, they can still insist on that. They would have to write it in or make it happen a different way. And I'm not going to cover every change like this right here. Electronic transfer now and wire transfers, just make it more clear what's already there. Okay, moving on down. Fuel tanks have been taken out of the fixtures paragraph. Fixtures paragraph is paragraph 2, and it starts on page 3 and goes into page 4. A lot of people forget about this section right here, actually, and I'll highlight it. All fixtures are included in the transaction, regardless of whether they are specified in this bulleted list or not. Sometimes agents will call the hotline and have issues with transactions and fixtures and sellers taking things or whatever. The parties are in a dispute about it. Just understand section A is here. Fixtures are included. If something's a fixture, it's a fixture. And I wrote a Q&A earlier this year that kind of talked about what the general legal analysis is to figure out whether something is a fixture or not. Now, is that something that you're gonna, take and advocate for your client in some sort of way that a lawyer would? No. But if you're in a dispute with another agent, then that's a resource you can use to hopefully resolve that conflict without the parties having to go get lawyers and fight it out in court, which sometimes that happens just because of the expense of the fixture. So, and sometimes those fixtures are pretty important. In any event, so what happened here is fuel tanks was taken out because it's going to come up later. So don't worry about that. Fuel tanks are just going to be covered in its own section, and quite frankly, I think covered in a much more relevant way. Over here, this was based on a Q&A I did earlier this year too, before the forms changes came out. Inflatable pools, spas, and hot tubs, those are not included in the, in what is or is not a fixture. Even if it is, even if you could argue that it's a fixture, which there are some cases where you potentially could, but now they are excluded. They're going to be excluded as a matter of contract. They're just not going to be included, even if there's been a special dedicated space created for that. All right, moving on down. I would say 7, here it's referencing paragraph 7D, the new fuel tank provision. Make sure though that you are careful with this section. Anything that's leased or not owned, make sure you're asking your clients about that. Make sure you're in depth about that. We get quite a few calls of agents who have not quite done as much inquiry as they should at the beginning of the transaction. And then it turns out something is leased and not owned. Well, you have to understand your seller can't convey more than what they own. So if they've got a fixture on the property that's leased, they can't transfer anything more than what they own as a result of having that fixture installed. Sometimes this can be controlled by statute, sometimes it can be controlled by the law, but in any event, your client would be in breach of this contract potentially because they cannot perform something on the other side for another contract that they're in with the fixture. So just make sure you're careful about this section, including section 7D, which is coming up. Now, this note was clarified to make more clear what is already in the contract. This was already there. There's no contingencies anymore in this contract except for one that I will talk about later on. There's only one contingency in this entire contract. Appraisal is not one of them. And frankly, I know for a while there, the appraisal addendums, I don't know if it got down to you guys or not, but in major metro markets, and even some rural ones, they were very common when the market was really hot last couple of years. Basically something to the effect of the buyer will agree not to terminate if the appraisal comes in low or blah, blah, blah. It was, and we wrote on this several times, I think those addendums are not hardly worth the paper that they're written on, because fine, the buyer can't terminate because the appraisal's low. Who cares? They can still terminate because they don't like the color of the shutters the next day. I mean, so what's the point? To me, what the goal of the seller was to make sure the buyer's going to have the ability to close if the appraisal came in low. Well, okay, that has to do with proof of funds. That does not have to do with some sort of document that doesn't give a lot of assurance about what is or is not, going to be a reason to terminate when you've preserved all the rights to terminate under the due diligence period, except for maybe this one. So in any event, I wanted to bring that up, but there's no contingencies in this contract, including the buyer's ability to get a loan. The buyer's job is to talk. The buyer's duty under the contract is to buy the property. Seller's duty is to sell, and it's not contingent on where the buyer gets those funds. Let's see. Moving on down. I mean, this was in here before, but it's been now bolded and underlined. The property is going to be sold in its current condition. So just understand that. Those are some technical changes. I'm not going to cover those. Yes. We'll talk about this briefly, but it's going to come up again later. Okay. There are some significant changes to buyer and seller costs with respect to HOAs, owners association, things like that. As you can see, appraisal, title search, and title insurance, those things all stay there. However, charges by an owners association management company in paragraph 9B. So when we get to 9B, we'll talk about it, but just be aware, that this section has been changed, has some different numbering to accommodate that new paragraph. So right here we have the new fuel tank paragraph, and really it's relatively simple. You go through, you check the boxes. Is there fuel tank on the property? How many tanks? One or two here. Tanks included in the sale. Buyer, seller agree any tank described above that is owned by the seller shall be included in the sale. And notice that is owned by the seller, right? This section right here. It's got to be owned by the seller in order for it to convey. And here's the I think one of the most important changes to this whole section. It used to be under the old contract that you could, if you were the seller, you could sell the fuel back and get that money as a credit. And all you had to do is leave enough in there for the buyer to, be able to operate basic necessities. But as far as the rest of it, you could sell it back. That has been changed. Any fuel in the tank cannot be removed now. Whatever's in there is going to be conveyed to the buyer. So make sure that if you have a property, the fuel tank, you explain that to your seller and explain, hey, we need to make sure we ask enough for this property that it's going to cover any fuel that's remaining in the tank. All right. Same thing with this paragraph here. It's been substantially changed because it is moved down here to paragraph 9. Some technical changes to the home warranty section. Nothing too big there, I think, to cover. Paragraph 9, though. It was the goal of the committee to make these costs as sensible as possible. It's kind of difficult. I don't know if you guys deal a lot with HOAs or not. They're more common in some areas than others. But HOAs are very creative about the kind of fees they charge and who they charge them to and things like that, right? So what this does is it tries to allocate the responsibility for those costs from the HOA by agreement between the buyer and seller so that hopefully they're paying what makes sense for them, okay? And so, there's some list here by the seller, but this part is still in here from the old form, and that is that the seller is going to pay for anything not specifically required to be paid by the buyer. And that's down here. So what does the buyer have to pay? Charges for providing information required by the buyer's lender. So if the lender is demanding something, that cost is going to be on the buyer. It's not the seller's job to, figure out how the buyer is going to buy the property or where their funds come from. Then number two, working capital contributions, membership fees are charges imposed for the buyer's use of the common elements and or the services provided to the buyer in connection with this. Now, this is different than, say some kind of transfer fee or something like that, something to release the seller and put the buyer in the place. That is not what this is talking about. This is talking about, the HOA says, all right, new member, when you come in, there's a move-in fee. You're going to have to pay that. And then finally, any fees that go along with determining whether there's restrictive covenant compliance. So if you're getting some kind of note from the HOA that says, hey, this property is not in some sort of non-compliance with our covenants, anything like that would be on the buyer. Otherwise, seller pays for all the other costs having to do with the homeowners association. Paragraph 11, as I foreshadowed earlier, is the only contingency in this contract. That is the only one, and it works very specifically. And there's a very important change to it this year. And that is this. If the property is not in substantially the same or better condition at closing as the date of the offer, reasonable wear and tear accepted, buyer may terminate by written notice. Now notice that if this happens, then it just relieves the buyer of their obligation to actually proceed in the transaction. Notice it's not going to be a breach by the seller. So it's not going to trigger any of those remedies. This is purely a contingency. It is the only contingency built into the contract. And the important change was this. There were some circumstances where, again, this was when the market was, going a little, before interest rates went up, market was a lot more active, a lot more transactions going on. There was a couple circumstances that came up where a seller would have, incur damage to the property during the course of the transaction. The buyer had the option then under the old contract to get their earnest money back and move on and not the due diligence fee. Or they could accept the insurance proceeds. And there were times coming up where the insurance proceeds, because insurance companies are, nearly Satan incarnate as far as I'm concerned, the insurance companies were not paying enough to cover the actual damages to fix the home. So the buyer was really left in an unfair position, the forms committee felt, in those circumstances. And so they felt, in the interest of fairness, the best thing would be to allow the buyer to get their earnest money back as well as the due diligence fee if there's substantial damage to the property and they elect not to continue. Notice, it's not a breach, but that. And then this portion here used to also just be tacked onto this previous paragraph, but now it's a separate paragraph just to set it apart because it's not exactly the same thing. And down here, paragraph 23, if you're not aware of this already, if your client is claiming that the other side has breached the contract, paragraph 23 is where all the remedies are for a party who has had, some kind of issue with the other if they've breached. So just make sure, I always encourage agents, do not tell your clients whether they do or don't have a case. And even though I'm clear on that, it's funny. I had a phone call, that's about a month ago, I guess. This guy called me on the hotline and he was asking me about a situation where the buyer and seller were having a dispute. One of them saying the other was in breach, blah, blah, blah. And I think his client was the supposed aggrieved party. And so, I told him, I said, listen, I will talk to you a little bit about how this might play out in court. Your client can argue this, they can argue that, but I'll tell you just for your own information. But you're not going to tell your client any of that. You're going to tell your client to go see a lawyer because it's a legal matter and it's not brokerage. And so he seemed like he was relatively clear on that. And then, after we said goodbye, he didn't hang up. And I was doing something, I can't remember, something at my desk. Anyway, so he was talking, and suddenly he starts giving his client the legal advice I told him exactly not to give them. And it didn't even line up with what I said. And so I just had to shake my head. I just don't, there's only so much I can do to try and keep you out of realtor jail. I can't do the things for you. But I always encourage agents, in these circumstances, when there's a dispute between the buyer and seller about who's doing what under the contract, tell them to get a lawyer. And if they choose not to, fine. You can advocate, see if you can work it out by consent, do what you guys do. That's all fine and dandy. But if it really comes to an impasse, there's just nothing else to do, and back out of it as quick as possible. All right. So those are all the changes in Form 2T. We're going to move on to Form 12T. This is the vacant lot land offer to purchase a contract. And we're actually not going to go very far in this. We're not going to go past this page because all the other edits in this contract are exactly like 2T that we just covered, but not this one because this is special to this particular form because it's a vacant land form. There's some edits. This opening note, I never liked it, to be honest, the way it was before. I think this is much better and a much better representation of what the statute is. You can use this contract to buy any sort of vacant land that has been properly, subdivided by the local government agency, whoever that is. Sometimes it's going to be the county, sometimes it'll be a city, sometimes it'll be a city county. I'm not sure what it is in your area, but there's a local government that either approves or disapproves of, a land being subdivided or petitioned. And if a seller tries to sell property that has not been properly subdivided, that's a misdemeanor, and it's punishable by the criminal statutes and not just some civil liability or something like that. So the old note seemed to indicate that anytime a seller was wanting to advertise some property that had commercial value, maybe to a builder or something like that, and maybe even some proposed plans, it sort of indicated that even in those circumstances, you couldn't use this form. But that just wasn't accurate. A seller can have a plan, maybe even a tentative plan about how to subdivide or advertise that, hey, this might be open to that, subject to and this would be an important caveat, but subject to the county's approval of subdivision, blah, 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 something to that effect. And so agents were like, well, can I use this form or not? And the answer is yes, as long as the parcel that could potentially be subdivided is fully encompassed in the contract, and the seller isn't just selling these proposed and not approved lots, then that's fine. That's perfectly acceptable. So that's what this note is about. That's what is hopefully all the changes that, honestly, I know it looks kind of confusing with all the strikeouts and bolding and underlining and everything else. That is the goal of that note, is to just let people know this can be used for any vacant property that has actually been properly approved by the local government. All right. That brings us to the buyer possession form next, 2A7-T. And actually, just so you're aware, the changes in here sort of mirror the seller possession also. So we're just going to cover this one. But similar changes are made to the seller possession form. The biggest, hold on. Yeah, okay. the biggest change that happened here is right here. I wrote a Q&A, I think it was last year, might have been the year before, but I wrote a Q&A basically explaining, hey, if you use the buyer possession form, and I should say the old form, then you as the person not in possession has no right to enter the property. Because most, well, the law says that unless the right to enter is reserved by the landlord in the lease, then there is none. So if there's nothing in the lease, then there is none. And honestly, these are leases. There's a lease between the buyer and seller. If one of them's taken possession with the other's permission, it's tenancy at will at a minimum. It is a landlord-tenant kind of relationship. So the committee felt that it was important to address this and to make it so that there's at least some right of access by the seller and the buyer, whoever is not in possession, some access for them. And what this says is, since this is a buyer possession form, seller shall not access the property during the term without the buyer's written permission, except in the case of an emergency. Seller shall be entitled to retain an entry key to the property, but shall deliver all other means of access to the property to buyer on the commencement date. The same thing for the seller. If the seller remains in possession, they got to give the buyer a key for emergency purposes, but that's all they got to give them. After that, and once it gets to the end of the term for this agreement, for this lease agreement, then the seller has to give all the keys and access to the property back to the buyer, or I guess finally deliver them to the buyer. Right now, paragraph 5, I still don't like this, and so I'm helping the committee rewrite it right now. But the point I want to make about it in its existing form, since this will be in use until July next year, there was a article that came out. It was WRAL in Raleigh, I think. It was a TV article, I guess I should say, a TV piece on, a seller had taken possession under the seller possession form and elected to just pay this penalty, this fee, this holdover fee right here, and claim that because they were paying the fee, they could stay in there as long as they wanted. Well, that's not true. It's never been true. And the court didn't find that, but the WRAL piece completely messed it up and honestly got the analysis wrong. So what I'm doing with the committee now is to revamp this to make it even more clear than it is now. But just so you know, if you get in that situation, somebody doesn't want to leave, just because they're paying this fee here doesn't mean they get to stay. They got to get out. All right, so those are the major changes with that form. This form only has one simple change that we'll cover, and that is right here, agreement to amend contract. This is form 4T, and it used to be, you would do an amendment and, there'd be no way to tell except by the dates what number it is or whatever. Here, if you have amendment 1, 2, 3, 4, anything like that. I'm also going to add some language here to make it clear that, unless they're changed by subsequent amendment, any amendment, let's say you have amendment number 1, you change the purchase price. Now let's say you do amendment number 2, and on that one, you just do due diligence fee. Well, I don't think amendment number 1 is superseded. Amendment number 1 still stands. So I'm going to add some language to make that more clear. I think that's true now, but I want to make sure that if you end up in court with one of these things, it operates how it should. And the last form we're going to go over today is the exclusive right to sell listing agreement, form 101. And this has some important changes in it. We're only going to do this form because similar changes were made in the buyer exclusive buyer agency agreement that we're going to cover now. So there's no need to cover it twice. As you can see, same changes here are going to be made with respect to fuel tanks and inflatable pools, things like that we've already covered. And 12N is to 7D, but same thing, it's a new fuel tank paragraph. This will be moved to another section, so that's been removed from right there. And here's the new fuel tank section here, and it's exactly the same as 2T. this right here, if you haven't dealt with this already, then, I think that's probably a good thing. This is not the way I would have chosen to draft this, so don't shoot the messenger. But it is the way the Forms Committee wanted to get it done. And, I will also add this on the Forms Committee, we do have at least one lawyer, sometimes more, from the Real Estate Commission. And they give their input on these things too. So this passed muster with them and the Forms Committee, so this is what we got, okay? The issue was this, and here's what caused this change to be made, especially with respect to designated dual agency. And that is this, is the commission was having too many complaints where the old designated agency provision was filled out. The client was under the impression that's the only kind of dual agency they had allowed, not realizing that the way that was written on the old form really gave that option to the firm, but not to the client. It was something where the firm could offer it if they wanted to, but they didn't have to. So there's a very, very substantial change right here with designated agency, and that is this word right here. If your client signs initials on here because they want designated dual agency, that means they are authorizing and directing you to do designated dual agency. That means you must do it. So make sure this is only being initialed if, in fact, you are actually going to do that thing and not any other kind of dual agency. If your client wants to do just regular dual agency, then you can do that here. And there are circumstances where you could potentially have separate brokers in the firm representing each client, but the firm still owns the agency agreements, and still both parties have authorized dual agency. So you can have your client say does or does not authorize the same individual to represent the buyer or seller in the transaction. Now, granted, I don't think there's any sort of significant point on whether the same agent is representing both parties or not, because if there's no designated agency, then the same limitations of dual agency apply to both of them, whether it's the same agent or two separate agents. But that's neither here nor there. It is a possible scenario that could come up. Basically, the easiest way to go through and fill this out is to just take it as it's presented. So you're going to start with dual agency. Are they going to allow that or not? Then if they are going to allow it, then you're going to ask, okay, is the client authorizing the same individual or not? Yes or no? Okay. So then, they make that decision. Then the question is, well, do they just want designated agency? And frankly, I think if they do the designated agency, then I think this paragraph here becomes a little less relevant. But, just because it's just not going to come up. I suppose it potentially could, but I don't know. I'm not, you would need to do some kind of written agreement, I think, in those scenarios to change from a client who's directed you to designated agency, but say the other side is not authorized designated agency. Then, if both sides don't agree to it, then you would have to work it out, some form or another, so that they both have agreed to the same thing. So just understand those conflicts can come up. Honestly, they could have come up before. So these changes don't necessarily exacerbate that, but just be aware of it, especially given the new direction component right here. And then if your seller doesn't want dual agency, they just initial right there. Paragraph 18, we don't really need to go through this. I pointed out earlier as we were scrolling down that the attorney's fees provision was moved out, of that one section there, and it's been moved down here. This really just goes through and talks about termination, breach, mediation, attorney's fees. If you got a client who's breached this agreement, then it will give you, the roadmap for how to treat those cases. Just understand that this mediation part, and I've actually had a couple listing firms hire us to go after their commission when the seller breaches the contract. And sometimes I have to fix this right here. because they go and they get angry, they fire off and maybe maybe file a small claims complaint, but they haven't tried in good faith to settle the dispute by mediation before going to litigation. So just make sure you're doing that. Make sure that's something you offer. If you don't, then it's something they could definitely bar your ability to recover that commission. And I believe that's it. It's not every single change that came out in July, but those are the most important ones. There we go. Those are the most important ones that I wanted to get through today to make sure you guys were at least aware of those. Happy to take any questions.
Yeah, I've got one. Is there anything in either of those, well, any forms that we have that force the completion of the contract? So like if seller decides they don't want to sell after all and they are under contract and buyer is like, no, I really want to buy your house. Are you able to force the seller to go ahead and fulfill the contract?
You mean, is the listing agent able to force the seller?
Well, is the buyer able to force the seller? So
Yeah,
I'm under contract, you're trying to sell your house and we're under contract and I want to buy it. You decide like at the 11th hour, nah, I don't think I want to move anymore.
Yeah. I mean, the buyer can take the seller to court and on a claim of specific performance and probably have a pretty good chance of winning.
Wow.
But as far as like a contractual provision, no. Contracts can't force people to do anything.
Okay.
That's why people breach them. If somebody breaches a contract, then your recourse is to take them to court.
Okay.
John, in regards to the fuel tanks, I know everybody always thinks fuel tank currently in use, but what about, we have a lot of properties that have maybe old buried fuel tanks that are abandoned, and very few times people ever disclose those. What is the liability? Let's say I'm an agent, I'm representing the buyer, I go in there. Later on, there's a fuel tank they discovered that's been abandoned a long time ago. There's an issue with it or whatnot. How is that best addressed? Or
Well, I think there's two different things going on here, so I'll cover both of them. The first is if you're a listing agent and you know about these things, a buried fuel tank, I think that's material fact. You better disclose it, or else you're going to risk getting disciplined from the real estate commission.
yeah,
That's number one. Number two, does your seller have to disclose that? That's a more interesting question that I don't know. There's no one right answer. It would just vary case to case, because a seller doesn't have a duty to disclose material facts. A seller has a duty to disclose latent material defects that are not within the discovery of the buyer by reasonable diligence. So an example would be, let's say there's a rotted floor joist in the crawl space. Does the seller have to disclose that? No, probably not. 99% of inspectors, if they actually get under there, are going to do it. I'll put it this way, a good inspector would find it. Reasonable diligence is going to find that, right? So does the seller have a duty to disclose that? No. Does the listing agent? Yeah. Oh yeah. I think it's a material fact. The listing agent would have to disclose, but not the seller. So the fuel tank, is this something the seller knows about and there's no little pipe or any other indication above ground? Then yeah, I think the seller better disclose it, or else, their buyer may have a pretty good claim against them later on, especially if it's an expensive cleanup.
yeah.
I had a case not too long ago where the tank was there, buried. Nobody knew about it. And I felt pretty confident that my client was telling the truth. But, my client was a seller. They'd sold it to somebody. The fuel tank was down there and just leaked oil everywhere. It soaked all the walls in the basement. I mean, it was a real mess. And my clients didn't know anything about it because the owner before them had put up some wood paneling that, didn't show any sign of, any of this going on. And there was nothing else to really tip them off. So it was an interesting case because, my clients were saying, well, we didn't know. And the previous owner saying, well, we didn't know. And the buyers are like, can none of you know? This is a serious problem, right? But anyway, I was able to get pretty nasty with them and make the buyers go away, and my clients didn't end up having to pay anything. But in that scenario, if my clients would have known, if they would have said, "Hey, yeah, no, we knew," we're going to testify truthfully about that because we have to. Then yeah, no, they can be looking at some liability there.
So what is it like on the disclosure when, if they truly don't know about it, and they put on the disclosure, there's no fuel tanks, and they find out what is their, I mean, are they automatically guilty because they put in the disclosure no fuel tanks, or is that?
No, I don't
Okay.
think so. Although, I've got a jury trial potentially next month on a similar issue where the agent and the seller, put something on the property disclosure statement that later changed. And it was a septic issue where they were trying to work with the county to get a resolution to make the septic work and to be acceptable to the county standards.
Mhm.
And the sellers were working on that process and told, any prospective buyer that they were working on that process. And then it turned out the county after the deed had been recorded, the county called and said, yeah, you can't fix this. You got to put in a whole new system. And so then it was something where, and I can tell you that the plaintiff's attorney on the other side is making I think, a mountain out of a molehill with the residential property disclosure statement, because they said that, there's nothing wrong with the septic, when in fact there was. They just didn't know it. So to me, to protect the seller, make sure you're always on top of them to change the residential property disclosure statement if something like that comes up. That is the best way to protect them. But in any event, disclosing material facts will also help them in those scenarios, and you're going to err on that.
I'm beginning to think that maybe with that RPD that it's best for a seller to do NA all the way down, so that way there is no, well, the seller said this and it's that,
Yeah, no, I think in some cases it'll be the best way to go about it. Sometimes if they fill it out and if they feel competent in doing so, it's going to actually, increase the value of the property. So
yeah.
Yeah.
Okay. Well, thank you very much. Appreciate it.
no problem.
Okay, I got another one. The charges that the seller is responsible for, where it talks about the HOA, the charges for transferring or updating the ownership, those charges are paid by the seller.
Mhm.
What if in the MLS they have under member remarks, buyer to pay those charges? How should they also have additional provisions addendum or what? Because unless it says in the contract the seller pays for those, but the listing agent has said that the seller's not paying for those, it's the buyer's responsibility.
Yeah, they got to change the contract somehow, some way. There's not one right way to do it. They're going to have to amend it, maybe strike through it, write something in. There's any number of things they could do to fix that. But anything in the MLS, if it doesn't end up in the contract, is meaningless. It just is.
Right. Well, I see. Strike through, or I mean, like, can the seller strike through seller to pay and just initial it, or does it have to actually be some legal type, here, Mr. Attorney, you fix this?
No, your client can strike through and add in things at any time. Striking through and adding things is perfectly. I'm not sure I'd recommend it in every circumstance, but if your client
Right.
wants to do it and they don't want to consult with an attorney, they don't want to hire an attorney to do an addendum, they can strike through things on the contract and write in, things that they want.
Okay.